Hi, I'm Adam Harris. I'm a director of Bowmans, and my field is insolvency and business restructuring. I'd like to talk a little bit about the business restructuring. It's a buzzword that's become quite popular at the moment. Unfortunately, we only have sort of 3 or 4 minutes to talk about it, so I'm going to try not to make this too much of a technical explanation. Essentially, business rescue, people think, is modeled on the American model. We've heard quite often about Chapter 11 bankruptcy restructuring, but in fact, our business rescue procedures are somewhat different. The idea is not really in the model of judicial management which we have at the moment, that you're going to be able to rescue a company entirely, but what the idea is that a business rescue practitioner is going to be appointed, and he will investigate the affairs of the company with a view to proposing a plan to the company and its stakeholders, and to ultimately bring the company out of business rescue proceedings on an agreed basis. I think the starting point is probably to say that we have really aged insolvency and company legislation. I kid you not, our Insolvency Act goes back to 1936. Our Companies Act, which is in the process of revision, dates back to 1973. The new Act, which Chapter 6, the Business Rescue chapter, is contained in, was signed by the State President in April last year, and it's expected to come in fairly shortly. At time of making this recording, we have been told probably 2 or 3 months down the line. One's not really sure. But significantly, the business rescue procedures set out in Chapter 6 are an entirely new feature of our commercial landscape. Just by the way, at the moment, it doesn't yet apply to partnerships or trading trusts or closed corporations. We're talking specifically about companies which are financially distressed. The definition in the Companies Act, the new Chapter 6, gives an outline of what financially distressed means. And you'll generally find that the board of a company will propose a resolution to place the company under business rescue. And they would do that if the company was financially distressed. Now remember that this is supposed to be an extrajudicial procedure. It's not a formal procedure through the courts, as for example the judicial management which we have at the moment is. So it's supposed to be cheaper, easier access, and the theory is that it's going to be a lot quicker than any of the existing remedies which we have. The business rescue would generally be started by a simple resolution of the board of the company. They would pass the resolution, and once that gets registered, it would have 2 effects. It puts the company under business rescue, and it also appoints the business rescue practitioner. Now, footnote that maybe for a little bit of a later discussion, but the business rescue practitioner is supposedly an independent person who would be appointed by the company with a view to coming in, managing the company on a temporary basis, and then proposing a plan to the stakeholders, which would ultimately result in that plan being approved and the company released from business rescue. If you're a creditor, you'll know that there are remedies which are available to you to be able to approach a court. For example, if you feel that there was an abuse of the process, you'd be able to approach the court to ask for the removal of the business rescue practitioner. You'd be able to approach the court to ask for the entire proceedings to be set aside in certain circumstances. I don't want to get too technical, but the Act itself is probably 18 pages, Chapter 6, and it contains a very convoluted way of thinking as to what the process is. But when you go through it, it's reasonably self-explanatory. And by the way, if you want to know anything further, please feel free to ask. But the ultimate procedure is that you would have the business rescue practitioner comes in, works with the board of the company with a view to that business rescue plan being approved.